breaking news out of New York. Sam Bankman-Fried.
Sam Bankman-Fried was sentenced to...
We have some breaking news. Sam Bankman-Fried, the FTX founder, has been sentenced.
A rambling statement of your innocence will just get you more time.
So many of our clients, have never been involved in the justice system. That's a basis of his autism, which did become a big part of the sentencing. He doesn't have the same intent that someone who would be super malicious.
Especially in the Southern District of New York, which we practice in sometimes, that is an unusual sentence. You know, you want not only a great lawyer who's going to fight for you, right, but they're going to fight for you all the way.
Hey everyone, welcome back to The Federal Verdict. I'm David Tarras, partner at the Rawson Law Firm.
Hello, I'm Marissel Descalzo, attorney at Tarras and Descalzo.
We're going to be talking about a very, very pertinent, very exciting and difficult topic for practitioners like Marissel and I that deal with complex white-collar cases, and that was the recent sentencing of Sam Bankman-Fried. Majority of our viewers, majority of people around the country and possibly the world have heard about the sentence. And we really, I think today, want to dive into not only the personal implications of the sentence for Sam, but also the broader scope of white-collar sentencing, right? Because this was a big sentence.
Yeah, and we should also discuss why it's unique to the world of white collar, because 25 years is definitely a long time. And when you hear that, and if you watch the news, you'll know that 25 years, sometimes you could be convicted of sex trafficking and not get 25 years. So we're here today to talk about why did Sam Bankman-Fried get such a high sentence? What were the factors involved? And what you can do to reduce your sentence or not get sentenced at all.
Yeah. So I think just starting off, generally speaking, you and I, attorneys in our field, are obviously fighting every day against these draconian, these way over-exaggerated sentencing structure as it relates to financial crime, right? Doesn't mean that people don't get hurt by financial crime, but no one's being shot, no one's being murdered, raped, right? But we're seeing numbers and sentences that are as high, if not higher, than in many of those cases. So from a general perspective, what is driving these high sentences in white-collar cases in federal court?
Well, what drives the high sentence is the loss number. And what is the loss number? It's a fake number that the government comes up with that claims that this is how much money is involved in the crime. In the Bankman-Fried case, it's a very big number because he's accused of being involved in a Ponzi scheme, lots of victims. And so the government adds up all that money together and says, okay, this is the amount of loss in your case, and that number really drives how high the sentence will go. In this kind of case. And maybe we should back up, and you want to give a little background on the case of Bankman-Fried?
Yeah, absolutely. I mean, he was, in a nutshell, operating what was touted to be one of the largest cryptocurrency trading platforms. He had the Miami Heat arena. He had the Super Bowl commercials with Larry David and Shaquille O'Neal, a very public figure, and based on his representations around the time when there was a massive tank in the Bitcoin and the cryptocurrency market, the company goes bankrupt. And this is around 2022. And then these allegations start coming out that perhaps this trading platform, FTX, was not, in fact, an actual trading platform where people were investing millions of dollars. I think the total value that the government ultimately said that he squandered was around $11 billion. And it did turn out, he did go to trial, and the evidence showed that he was essentially just taking investors' money and spending it on personal expenses. He was contributing to political campaigns. He was a top political campaign contributor. That made this a very high-profile case. The advertisements, and it's kind of, at least in the government's perspective, I know his lawyers, and we would certainly have argued otherwise, right? But the government really built a case and successfully built a case that was kind of more of just a classic, you lied to investors, you lied to customers, you made billions, you stole it, and you used it for your own goods.
Right. And I think what really also important in this case is that immediately upon FTX tanking, because I think there was a fallout in the crypto market at the time, because cryptocurrency is so volatile, everyone that was close to him at the company starts cooperating. They immediately turn themselves in to the government to reduce their sentences, and Sam is the last one standing, right? And I think that kind of was part of the reason that he is dealt with so harshly. And I also think that what did him in is that this was the first big crypto case that we hear about in the news every day, and the government and possibly the court wanted to make an example out of him.
Absolutely.
So he had things stacked against him from the start, I think. And I think that all of those factors contributed to that long sentence he received. But also the judge was pretty upset at him at sentencing. And you want to tell us why that was, David?
Yeah, absolutely. I mean, I think we certainly as practitioners, right, we see the signs of a case that appears to not be going someone's way, and also potential signs of a judge who has become too personally invested in the matter. From the very beginning, right, when there was issues regarding his bond was revoked. He was taken back into custody, and we'll talk about that in a little bit regarding the media and how the government plays it, but we can't, and how that affected him, right? But there were definitely specific areas at his sentencing that the government took big issue with, and it's something that we have to deal with all the time, right? When we're going to a sentencing. Now, he went to trial. He stood his ground, and he fought. He maintained his innocence, and he was convicted. So we know that the sentence is very commonly going to be higher, if not significantly higher, kind of on the same grounds that you mentioned before. Everyone wants to come in, cooperate, take a plea. Statistically and historically, they're going to end up with a better deal. He went to trial, and he was found guilty. Now, at the sentencing, there was a few areas where the government, where the judge really focused on. I think first and foremost was just this concept of a lack of remorse, right? And that's a really tricky one at sentencing for us and our clients, because especially when someone goes to trial, it's not unfathomable that only 70 days after, they still believe they're innocent, and they still believe in their appeals, and it's hard to show that remorse, right, when you're so invested in your defense. And the judge here took a huge issue with that. I mean, really called Bankman-Fried out for saying, you've spoken for 20 minutes, and I haven't heard you once say that you have remorse for your crime. You said you made mistakes. You said that you regret certain actions you took, but I did not hear that remorse that I needed to hear, right? And when we hear judges say that regularly, what about remorse, right, in sentencing, in your experience, Marissel, is so important? And how difficult is that when, after a trial, you may still be in the process or likely in the process of an appeal, if God forbid there's a guilty verdict, to go and give that allocution and express that remorse for our clients?
Well, I'm going to start by saying that every client has a right to allocute at sentencing, and so they have a right to say something. And I'm sure that the lawyers representing Sam maybe couldn't control him and couldn't control all the things that he was saying.
It's what it seemed like.
And I think that, when you are a defendant that went to trial, and you plan to appeal because you feel like you were wrongly accused, I think that your allocution needs to be very tightly controlled by your lawyer, or alternatively, you need to say nothing. Because, a rambling statement of your innocence will just get you more time, and you don't know what the appellate process, what's going to happen on the appellate process, and almost, leaving the arguments up to your lawyers is almost kind of the best option. Those are the options I give my clients. I will say that I have had clients that don't follow my advice and say that they want to allocute regardless and give their explain why they're innocent, and it never goes well. On the other hand, I've had many instances where clients get up, look the judge in the eye, explain, and these are very, and all these allocutions with my clients are very, carefully crafted.
That's the key, right?
To the judge, right, and to what the judge likes, and when it's very carefully crafted to something that will get to the judge and that the judge will listen to, it has a positive effect. And I've seen judges scratch off a number and put a lower number,
Absolutely,
on their piece of paper, and I think that things can be done. I think, unfortunately, for Sam, it was just a train wreck from the beginning, and maybe the reason he went to trial was because there was no plea offer. It's very possible, and so we can't fault him for that. Maybe the plea offer was a life sentence.
right.
Because the prosecutors were asking for 40 or 50 years. So kudos to his lawyers who secured a 25-year sentence,
Right.
which cut in half what the government was asking for.
Right. I mean, in a way, that's a massive win.
It is.
He goes home in very likely 12 and a half years, right, with gain time and with the First Step Act. So he's got a life ahead of him, and sometimes you do have to make that hard decision. What do you make of, now his lawyers asked for about 5 3/4 to 6.5 years as far as their recommendation. The government was asking for 40 to 50. His guidelines were life. They were in the hundreds with that kind of loss value, which is just preposterous, right? But that's what we deal with
Right.
When those high loss cases. When you're going into a sentencing, I've always found one of the hardest conversations to have with the client is especially so many of our clients, so many have never been involved in the justice system, right? They haven't, they're not career offenders. They haven't ever been incarcerated before. So when your guidelines are so high, especially in a financial case, a lot of times we have to tell our clients, look, it's probably necessary for us to recommend a certain amount of prison, right? And it's almost like a self-preservation decision. How do you approach that with your clients?
I think that it's a difficult conversation, as I'm sure you know. I think that in very few cases can you ask for zero time, but sometimes that's what the client wants. I think that backfires often. I think the number should be something that's realistic, and the more realistic the number, the better your chances of getting that number
Right.
for your client.
And I agree. And I think what I've always found is if the guidelines are astronomical, but the mitigation, right? We do so much work, whether it's after a plea or after a trial with a guilty verdict, God forbid. We have so much still of a fight left in order of gathering the mitigation, presenting our client's life in the right way and matching with the sentencing factors. And I always feel that if the mitigation that the client has, if their life story, if their history, their characteristics, their charitable works, the hardships they've overcome in their life, and the nature of the case itself and their role in the case, if it matches a certain sentence, even if it's way below the guidelines, and I think go for it, right? If your client says, I'm not comfortable with asking for any amount of prison, I know my guidelines are very likely to end up in that, but this is the story that I have, then I think it's always, for the most part, worth telling. And you have to know your prosecutor and you have to know your judge, right? We always pull all of the sentencing statistics to see what is this judge like, what do they not like, things along those lines. Another interesting aspect of his sentencing, of Bankman-Fried's sentencing, was the judge brought up a lot of statements that he made during trial. During his trial testimony that the judge found to be false, to be, I think he referred to them as hair-splitting, inconsistent, weird. So it almost seems that there's almost a trend that he may have just been a client who had his own free will, right? Because we prep our clients so much for their testimony, if they're ever going to give up their Fifth Amendment right. And then you have this kind of pattern of how he testified at trial, which was described as kind of rambling and evasive, and then you see the same thing in his sentencing, in his allocution.
Well, I will counter that by saying that I believe that Sam Bankman, is it Fried or Fried?
Fried.
Fried.
For Fried.
I'm not sure,
Oh,
but doesn't matter.
Yeah.
So there's something about that case and about that particular defendant, which is that he had some mental health issues.
Absolutely.
And I think that those affected his testimony and probably his allocution. And that's something that, maybe the judge didn't want to take into consideration because of the type of, persona that Sam, portrayed, but maybe that went into the way that he behaved. And also, yes, of course, every defendant should be properly prepared to testify, but he was detained. So it's very hard to prepare a client to testify under those circumstances. And so, decisions have to be made of whether you have the client testify at all. And again, not a decision up to the lawyers. The lawyers can give as much advice as they want, but it's up to the client whether they exercise that constitutional right that they have. I think in a case like this, I probably would have counseled the client not to testify, but I'm also guessing this is a client that insisted that he wanted to. So it's just very hard to manage, and that's why you need to have a lawyer when you're charged with a federal crime who's extremely experienced in federal practice and in all these nuances, because you have to learn how to navigate and maneuver all these things. Not saying that Sam's lawyers didn't know, because they were very experienced, well-known, great lawyers, but these are just some of the obstacles that they face that often when you're talking about a case or you hear about it on CNN or the news, they don't understand these nuances. So I think it's important to point these things out.
Yeah, no, absolutely. 25 years, it's scary, right? For the practice in general of white collar, complex criminal defense, the judge, himself, when we think about why do judges give the sentences that they do, right? And we're talking about, at least as lawyers, and as we're always explaining to our clients before a sentencing, these are the theories of punishment, right? And here, I think the judge, and they don't always do this, but the judge took a focus on both specific and general deterrence. And when we talk about that, it was the Judge Kaplan finding that I believe 25 years is appropriate, not just to scare the public or scare anyone else who would ever be considering this. You don't do white collar crime, right? That's how we stop it. We launch people, and we hate that, right? It's not right, because we want a judge to focus on our client, right? Their story, the person sitting in front of them, not the next person. This is the person here that is in front of you that you should be putting your attention towards. But wanting to scare the public, wanting to scare other potential bad actors is always a big part of it. But here the judge also made a very clear point in saying that because, and this goes directly to the mental health aspect, which I found so interesting and obviously is a big point of debate and discussion among our colleagues and legal scholars, is the judge said to Sam, you are not comparing to a Madoff who got over 100 years, right? You are not I believe the word was serial financial killer. Okay? You're not someone who wakes up every day and says, I want to ruin people's lives. You're someone who has a math brain, I believe was the term he used, right? You wake up and you're crunching numbers in the way your brain works. And the judge almost used that. His lawyers were very articulately arguing that that's a basis of his autism, which did become a big part of the sentencing. He doesn't have the same intent that someone who would be super malicious was. And the judge says, I understand that, but that scares me as the judge, because what's going to stop him if I give him a 10-year sentence of him getting out? What's going to change about his brain? And, I don't know if there's a resolution to that, right? I mean, you have to have always have experts, have your clients evaluated, really flesh out what is the underlying mental health, but it's always a real challenge when it comes to that.
Yeah. I mean, there's all these tools that we as lawyers can use to mitigate a sentence like that. And I think that especially in the Southern District of New York, which we practice in sometimes, that is an unusual sentence. You usually get much lower sentences in that district as opposed to, our home in Florida. So I think that's why it was so shocking for everyone. And then everyone at the same time was also shocked because it wasn't a Bernie Madoff sentence, right?
Right.
And Bernie Madoff didn't go to trial, and he just kind of turned himself in. And I think the difference is, you identified it, that the Madoff was a consistent serial behavior for years, and Sam was maybe a one-off in his life, maybe, but he's also younger and he's going to be able to rebuild his life. It's still going to be terrible. It's still going to be a long time, but it is definitely an example of what to do and what not to do when you're representing a client, and what types of mitigation will work with certain judges, because clearly this judge had his mind made up.
Sure. And you have to know your judge, right? That's crucial, as you and I always will do prior to a sentencing, maybe even much earlier in the case, not to be morbid, right? But we have to know what does our judge like? What are similar cases? How have they resolved? How does a judge sentence the specific judge on your specific charge? How do they sentence after trial, after a plea? What mitigation, what presentations to them at sentencing work and don't work? Just one of the many tools that we need to use, right, on a daily basis.
Absolutely. This is just part of our, daily practice of what we do, because unfortunately a lot of what we do is sentencing. But sometimes, you want not only a great lawyer who's going to fight for you, right, but they're going to fight for you all the way and all the way through, including at sentencing. Yeah,
absolutely. So what do you think is next for him? Appeals? Where are we kind of going from here? What do you expect?
I think he's definitely going to appeal.
Yeah.
I expect for him to appeal. The problem is he testified, though, so the testimony makes it very difficult to appeal the conviction. Because once you testify, there's all this case law out there that basically says it's the jury believed. If the jury believed the defendant, then nothing else mattered. And you might be able to appeal some of the sentencing issues, but certainly appealing the case is much, or the conviction is much harder. That's why that's another discussion you have to have with your client when they're deciding whether to testify, is that, you're going to make your appeal that much harder. But some clients want to do it. So
it's their right.
Yeah, it's their right. But if he plays his cards right these days, he will serve half the time and in a much better location than he is right now, because the judge did order for him to be sent to a lower security prison.
Correct.
Now that was unusual, wasn't it?
And I think he even said, I strongly recommend in the order. Usually, right, our judges, at least mostly in Southern District and probably around the country, are like, look, I'll make a recommendation, right? When we ask them to go somewhere, and we tell our clients that too. Just so you know, you might want to be at a certain facility, but the judge is going to say these magic words. This is just a recommendation. It's not up to me. But this judge went pretty hard as far as the recommendation goes. Right?
I think so too. And I think that goes a long way with BOP. Like BOP will take that into consideration. And so instead of Sam being at this high maximum security prison, he'll hopefully be at a camp or a low, and where his time will move by much faster.
Yeah, right. There's definitely wins within the loss here, but I think it's we would both agree it's going to have definitely a ripple effect and ramifications for kind of how we approach sentencing in all of our cases now that this standard, so to speak, has been set and this kind of warning sign is out there. We've certainly seen it before, but this is a big one. Yeah. So we definitely are going to be following up on it.
Yeah, absolutely.
Yeah.
Well, thanks.
Yeah, thank you
for joining us on the federal verdict today.